Joining us now, New York Times reporter and MSNBC national security analyst Michael Schmidt and state attorney for Palm Beach County, Florida, Dave Aronberg. Good to have you all on board this morning. I'm curious as to why Dave Aronberg just share some of the documents. Why not?
Good morning, Mika. I think this is an outgrowth of the frustration of the January 6th committee that the Department of Justice seems to be dragging its feet in the investigation. Remember, DOJ has even more power than the January 6th committee to compel evidence because their subpoenas are backed by the authority of the Department of Justice, where you go to jail if you don't comply. If you don't comply with a January 6th committee subpoena, well, then you could have to go to a higher court and talk about it more. Or then eventually it goes to the Department of Justice to decide whether to enforce those subpoenas. And there's frustration within the J6 committee that Merrick Garland has refused to enforce the committee subpoenas when it comes to Dan Scavino and Mark Meadows. And so when you combine that with the slow pace of the investigation, where DOJ, it seems to be drafting behind the committee, where it should be the opposite. DOJ usually would take the lead. So here, the committee is saying, hey, we're doing all your work for you, man. So, step up and be more aggressive. And I think that's the basis for this turf war. It's ugly, but I think this is an example of the J6 committee pushing back.
So, Michael, you have new reporting for the New York Times on the possible hurdles to prosecuting Donald Trump for crimes relating to January 6th. You co-write the piece, and in part it says this: if the Justice Department were to bring a case against him, prosecutors would face the challenge of showing that he knew or should have known that his position was based on assertions about widespread election fraud that were false, or that his attempt to block the congressional certification of the outcome was illegal. In investigations that are focused almost exclusively on physical action, prosecutors do not need to focus on proving intent, since the link between the action and the harm is typically clear. The question of intent can be muddy when the crime under investigation involves an action in which the defendant's state of mind can be hard to establish. The crimes that legal experts say Mr. Trump may have committed, obstructing Congress, defrauding the American people, and seditious conspiracy, fall into that bucket.
And yet, Michael, we keep hearing one witness after another saying that they told Donald Trump that his claims were specious. They told Donald Trump that they were crackpot conspiracy theories, and he seemed to acknowledge that. Even his own lawyer said he understood that some of the stuff was illegal and that the Supreme Court would strike it down 9-0. Does none of that testimony seem to have an impact on establishing intent?
So the biggest piece, the biggest disclosure that we have learned that moves the question on intent is what you're referring to, is the fact that when the vice president's lawyer was testifying last week, he said that in front of Trump, John Eastman had said that the legal theory that they were pursuing was essentially baseless, which is essentially bogus. But they went ahead and did it anyway. And in terms of moving the ball, in showing that what Trump knew what he was doing was wrong, that he was undertaking a wrongful effort to overturn the election and was not simply, believing these fantastical things about what had happened with the election, that was a significant development. And when we saw that and we looked at that, we said, well, this really helps explain the question of intent that the government will have to wrestle with and deal with if they were to bring charges, because you're dealing with someone like Donald Trump, who has a highly unusual, abnormal relationship with the truth, who knows what's really going on in that mind. But that conversation with Eastman, in which the vice president's lawyer testified to, significantly shows that the president had been told that the legal effort was wrong. And if he were to say, well, I ignored that, then he willfully did that. He looked the other way on legal advice about how he was going to use his power at one of the most critical, if not the most critical juncture of his presidency.